Now the evidence is getting good. The defense arguing for this petition. Let's bring in National Trial Attorney Michael Jaafar. Thanks for joining us, as always, Michael. And listen, I mean, we know that Jason Autry, co-defendant, allegedly recanted on video. It wasn't under oath, so this judge said that can't come in as new evidence in this evidentiary hearing. So the defense has to get new evidence in every way that they can to get the special agent who investigated, who was involved in this case, to admit, number one, I don't believe Jason Autry raped Holly, and number two, I can't say that Dylan was lying or not. Maybe he was. I think I'm surprised. How do you feel about that testimony?
Judge, actually, there's our system of justice and sense of justice. The two are not always the same, right? The system of justice, I think, in this specific case, can wind its gears in a way to prevent him a new trial. I think our sense of justice, however, tells us that if, in fact, the person who put him behind bars was material, his testimony was so material in putting him behind bars, if that person is recanting, he said, believe me, I was involved in a case exactly like this. Exactly. The person who found out was the trigger person said, I actually did it, not the person that's in jail, but because he wouldn't testify under oath. The system of justice cannot undo and disturb a jury verdict because of somebody saying something that's not under oath. So at the end of the day, it is getting very interesting. The defense are very angry. They are very bad. You could tell as a former defense attorney when you believe your client or when you don't believe your client. These attorneys truly believe their client is innocent. And it got into a shouting match. We're witnessing a knife fight between this detective and the defense attorneys, and it's getting very heated. It's getting very interesting. I'm riveted. I want to see how this thing ends, but I think without the actual testimony by the person recanting it, I think the judge is not going to give them a new trial.
Well, it's interesting, Michael, because I like your statement about the sense of justice versus the system of justice. And ideally, you can align those two things. That's one of the frustrations of being a defense attorney. It's always hard to kind of get there sometimes. The way they're doing it here is they don't have the person coming in. He cannot come in. Well, he's not coming in, and they can't bring in the tape version of his recantation. But what they're doing is they're going step by step to some of the things that he's saying and trying to show this judge, look, this is why that's not true. This is why that's not true. This is why that's not true. Mike, the judge may not agree, but I think the way they're doing it is the only chance they have, and I think they're doing a fairly good job.
Under Tennessee law, they would have to prove that the evidence that they're bringing in now could not have reasonably been put together in the first trial with any kind of reasonable diligence. And the only thing I think that rises to that standard is the recantation, which is not going to be considered. Everything else could have been brought together. They're basically relitigating the case. And as we know, relitigating a case is not enough. Again, this is not the first time this has happened. This has happened multiple times, even in my career. A person is behind bars, and then later on, another person says, I did this, unless it's under oath or can't be brought in, judges just don't give it any credence.
It's going to be a rough situation for him.
Yeah, we're going to see what happens. It's interesting.
All right, let's step aside here, folks. We'll have more. Let's bring back in trial attorney Michael Jaafar to discuss. Michael, one of the things that's jumped out at me about some of this testimony is, number one, how hesitant this particular guy looks. Now, it could be because it's years later and he's retired now, or it could be that, in fact, he just doesn't quite know what goes on. He said, I collected evidence. I gave it to the prosecutors. One of the things that was interesting is there were a number of different statements that didn't quite line up, but yet they took Autry's statement as the one that they were going to work with because it was the closest to the facts. And we don't know where that statement came from. Sometimes, you know, they can feed them information. Any of that going to work at all for the defense under the circumstances?
I think it will. You know, here's the thing. I'm also vacillating on my opinion on whether or not the judge is going to grant this because this detective has been on the stand all day. And we know that throughout the day and earlier on, there have been multiple dramatic moments where the defense attorney got him to admit, like, he even asked him, hey, do you sleep at night? Does this case weigh on you? Do you think that there's a chance? So, I mean, he has been vacillating. He's causing me to vacillate. I think absolutely the defense is just taking him to task. But this crime happened 14 years ago. The investigation was concluded, I think, 13 years ago. So, and you know, so obviously he's not going to remember most of it. Will it sway this judge? Again, I'm having a little bit of PTSD from my own, you know, work in in this arena and how judges they just don't want to disturb jury verdicts against all odds unless they have an actual testimony under oath by somebody saying, yes, I lied, I know, I saw something, right? And so it's all being put on this detective, and so it's just going to be, it's like a Rorschach test at this point. I don't know. My own opinion has changed in the past hour. I can only imagine what's going to happen with the judge.
So why do you think Jason Autry isn't testifying? We don't know that we expect him to testify. He's out of jail. Maybe they can't find him, but it just surprises me. All right, put him under oath. Let him testify.
Not a surprise at all. This is, again, 100% what happens in all these situations. The reason he's not testifying is because he has been told by the prosecutor that if you testify that you lied, we're going to put you in jail for several more decades, and we're going to undo the plea that we gave with you. The plea we gave you was that you were being honest in your testimony, so we're going to undo that plea. We're going to put you back in jail. We're going to put you on. You're going to be without bond, without bail. That's exactly what happened. Again, Judge Ashley, this happens all the time, and witnesses all the time are offered a plea, or they take a plea, and then later on they say in a jail cell or to somebody, I lied, and then they'll tell you, hey, you come to court and you say that you lied under oath, thereby forcing us to release this guy and do a new trial. We're putting you in jail again. So that's exactly why he's not testifying, and he won't testify because he's free. He's got the freedom of the freedom, the sweetness of freedom. So he's not going to testify.
Wow, that's a good reason for it. Michael Jaafar, of course, thank you for joining us tonight.